Let's start about, yes, thinking about the story what you might live every day. So you are living this situation every day, maybe in your everyday work. So there is actually research done at the university. This research might involve other persons, other also collaborators, which are not belonging to the university, a third party in any case, somebody from industry, somebody outside just the university from another university, who knows? Of course, it involves also people who are working in that industry, different actors. For example, the researchers on one side, you as actually technology transfer officer, also the interests of the university itself, and so on and so forth. So it might be actually a bigger question. You might need some investment. Then there is a question, shall we go for a protection or shall we keep it a secret? If we want to keep it secret, however, we need some investment. We might be obliged to show to the people what we are doing just by telling people, yes, we keep it secret, so please give us some money. It won't work. They have to be sure that even if you keep it as your secret, there might be some hope of some success. Otherwise, they won't pay some investment or they don't pay at all. And then once maybe you have that IP or you have that secrecy, you want to earn money by maybe licenses and so on. So that is actually a story which you know all, which you have seen several times during your working time. So, and in fact, and each part of it, there are contracts which are quite important, and they are very, very, let's say, necessary. A contract per se is, let's say, a tool that translates, on the one side, maybe technology or a contract, especially in this, let's say, environment, is a tool that translates the technology or a technical solution or something like that into a tool of law. It becomes an object of law. This object of law is quite necessary, especially in order to show what are the limitations, where you are going, in order to also to be there once things are not going so well. I mean, the contracts are even very important in your private life, so you might be married or not, but if you are married, that is a sort of contract as well. So when everything is going well, it's of course quite correct. Once things are not going well, you might be happy to have even that contract with your ex-partner. So you see, actually, the contracts are quite necessary in all aspects. But we are going somehow to just be involved uh, with contracts which might appear during the cycle of innovation. The cycle of innovation starts with an idea. You see, for example, on the top part of it, you have, let's say, you have first the idea, and these idea of your searchers might lead to an invention. So there is actually a first decision. Do we want to make an invention disclosure, so to patent it, or not? Uh, or we don't want to do it. Do we want, for example, to make an invention disclosure without patenting it, but by just publishing it? That might be also a way to do it. Or that is actually the assessment you have to do. Then you might decide to go for an IP right. So that is actually the protection. Once you have this protection, uh, having a patent, we discussed about it very long as we talk about IP management and so on. And we saw that just by patenting something, what you do is actually lose money. So patenting are costs, if you want. But you do the cost only if it is a cost for an investment. So it is done in the hope of an investment which will have some return. And this return shall come in through marketing. And one of the ways you might get the money back is, of course, licensing. And all that will lead to a financial return, and then these financial return, especially in the case of the universities, they can reinvest it again in research and development, which would bring us further inventions and so on and so forth. So that is actually the circle we are searching for. And that whole system is actually a technology transfer process, taking the technology from the research part of the university and bring it to a marketable, let's say, product, which is maybe done with an external partner, or even actually with some that is actually the idea we have to make some startups which come out of the university and they use their own ideas to do marketable products. So uh, the question is actually, where in these circles do we need an agreement on the other on or other let's say actually if you think others, do we need any agreement at any moment? And the answer is mostly everywhere. You need in fact an agreement at every part of it. So the form of these agreements might be different from one to the other one. And then what type of agreements, for example, is actually to find out who has the ownership of the knowledge. So whom belongs actually this knowledge? Of course, if you think of the inventor said, "I actually invented it. That is actually that is my ownership. It belongs to me." Yes and no. Most of the countries, or there are other, let's say, provisions, as for example, the provision in Switzerland, which stipulates that the invention which was done during your working time belong to your employer, and the employer is in that case university. So even if the knowledge comes from the researcher, uh, the ownership who owns these protection title is in that case legally the university. So, but these are things that shall be also clear, and you might need actually these type of agreements when you are writing the let's say work contracts with the employee, so that employee is aware of what is coming to him. So these types of agreements about the IP shall be regulated also in work contracts as well. Then you want to talk with somebody else, make sure you did some non-disclosure agreement before going further, because these non-disclosure agreement is quite necessary for further cases. First of all, you don't want to lose it, and you would like to have something legally binding so that the knowledge remains at your disposal and how you want to use it. On the other side, a, a disclosure, we have seen it at the beginning, in any sort, any disclosure, any sort, is killing the novelty. So by not using a non-disclosure agreement, you might even kill the possibility to have an IP right further, such as a patent. Then once you come to buy, lease, rent, loan, hedge a claim, and so on and so forth. In that case, of course, in order to be clear and how to do it, you need, of course, a research agreement. So that is another sort of agreement that you need. You have to make clear who, for example, who belongs let's say, the IP rights after the collaboration, and then who belongs actually the IP rights before we start the collaboration too. So all that shall be also cleared in those type of allegations. Then you need, of course, maybe some attorney, and for to be sure what the attorney is allowed to do, what is he not allowed to do. You need to give him a power of attorney, and this power of attorney allows him to put some non-disclosure agreement, in fact, so that you can use it when you are working with other persons. So then, if everything goes well, then you come to the licensing, and then you have these licensing, let's say, possibilities. So the point is actually it is a bit too rapid. So you don't come to licensing that rapidly. Before coming to that, you start with a negotiation. In the course of negotiation, you start normally with a letter of intent. So what is a letter of intent? Is in fact a sort of agreement that includes time and limitations, subject matter, secrecy, and in fact, it is just saying, okay, what is the time of the whole this negotiation? What shall be kept secret? What is the subject matter we are talking about? And then, of course, it is not binding to sign an agreement afterwards. It's just an intent that is accepted for both sides to make some negotiations and make clear, especially, what remains confidential. So that is very important. Then in the next step, you might have some pre-contract. So in pre-contract, if everything goes well after the negotiations, after the letter of intent, you have a term sheet that might lead to sign the agreement if, for example, all pre-requirements are fulfilled. So that is actually a pre-contract. And then even in that case, you are still not automatically by the case of a license. Then you might write an option. An option is actually if one of the parties is saying, for us it's okay, and then only the other party is still actually not quite decided about that, only this part can ask for the signing of the agreement. Normally the agreement would be the license. So you see, even actually, all that negotiations is not starting with writing an agreement like the licenses. So we are we would talk about license, of course, a lot, but that is not the only thing we are talking about. So let's start to talk about the one of the first things you might get involved to when you are starting such let's say externalization of the information, and that is nothing else but a non-disclosure agreement. I wanted to give an example which we have that is at our office, uh, how that is going. For example, the very important sentence is that the IPI, that is us, the Institute of Intellectual Property in Switzerland, maintains complete confidentiality concerning all searches. It is quite, let's say, general, uh, good intention and so on, but still, we need actually something, as I told you, which is seen as an object of law. So it is, of course, most of the judges would say that is actually very important to have that sentence, but you need formally maybe a bit more. So the non-disclosure agreement, as we see it on our side, is something like that. So first of all, we say who are the parties. So there's a receiving party here to desires to participate in discussions regarding, and we say actually regarding what? That is a transaction. So regarding, for example, here in that case, it is about searches, patent searches we are doing. During these discussions, disclosing party may share certain proprietary information with the receiving party. Therefore, in consideration of the mutual promises and covenants contained in this agreement and other good and valuable consideration, the receipt and sufficiency of which is hereby the parties here to agree as follows. So all that had been said, just to say actually what we are going to be agreeing on that. So we receive some proprietary information, and so regarding that, we shall state what should be seen as confidential. So which part of the whole thing is confidential? Then how the confidential knowledge can be used in for what effect, what is actually what is the limit of that use. Okay, so it is actually used to make a search, for example. It's used in order to make clear our negotiations, whatever the usage is. As for example, are they allowed to share it with somebody else? That is a use which goes beyond maybe what you would want. So it shall be clear in that contract what is the use and how far are you going. Then the next thing is about the term. Uh, these, let's say, will end one day. So we are not going to make a contract of, I don't know, for the eternity. So you have to give a term, how long does it goes, and how far it goes, and so on. And if something goes wrong, and that is very important, what are the remedies? What are the remedies you think? If, for example, one party who signed this contract, he knows that what is the limitation of the use, abuse his power and use it in other terms. What are the remedies? What would be the fine for that? Okay, and if you give them, for example, some confidential information or material, how shall they actually return the confidential information? Shall it actually, shall they keep it, or shall they, I don't know, destroy it after the term of this agreement, or shall they give everything back? And if they, of course, whatever they have in their heads, that shall be there, without, that goes without saying, that shall not be shared with other people. So that is actually very important. And then all that can be signed. And once it happens, the other one would say actually, oh, oops, I did it. What now? So what are the warranties? What can you do in terms of warranties so that both parts are sure that the confidential, let's say, material will be kept confidential. So the warranties are also very important part of the agreement. So let's see if some of the aspects we talked about, we can see them again in our practical example. The example was from the, let's say, the agreement we have seen. So in that case, it's actually a research agreement. We do some searches for our customers, and then we have some agreement, some confidentiality agreement, and some research agreement with them in order to do from both sides the work correctly. So let's see. Actually, we find the aforementioned let's say characteristics. I told you what term and everything, and if we can find them again. So first we do start with actually the general terms and conditions, the general scope, for example. So here it said that these general terms and conditions apply to commercial services provided by us under the label IP search. That's our name when we are on the free market. So, and especially what is said is that any other general terms and conditions and declarations by the customer will only form an integral part of the contract if expressly agreed in writing. So, what is not agreed specifically and expressly in writing is not part of this contract. Then what applies are about cost and rates. So the final price is calculated according to actual time and effort plus database cost and so on. So we tell them actually what they are going to pay, and we detail it in our, of course, let's say receipt that we send to them, actually factor what we used in time and so on. So that is actually just about the prices, the general, let's say, aspects of monetary part. Then, okay, that the order should always be made in writing by fax, email, or by using the online order form. Transmission errors and discrepancies are the responsibility of the customer. So again, the terms are set clearly. What do we accept? It shall be in writing form. So actually, formally, it is clear what is accepted. What is said on telephone is not maybe accepted afterwards because it is quite hard to reconstitute what was exactly said. So we need it in a written form. Otherwise, that would not be easy for us to handle that. Then about the warranty, we had this actually as one of the terms. For example, the IPI applies due diligence in selecting information that are our duties and executing searches. However, no guarantee can be given for the accuracy and completeness of the retrieved data, nor for the search results. The IPI shall only be liable in case of gross negligence and intent. So we are people, we are human beings, we make mistakes. We might actually have overseen a document, which is very important for our customer. And the only case that we are liable for that, if it was so clear and we did actually a big bad mistake. Otherwise, people can do mistakes. So that shall be also clear. And in order to make it clear, we put it in our general conditions. So things that you have to think about it. Things can happen, things can go wrong. So when are you really liable? If you did really neglect something, you could have not neglected it. In that case, of course, that is, for example, it was written, I want that, and you did not even search for that, and that is actually not to apologize. So that is what we accept. The information contained in the search report does not constitute legal advice, nor is it to be understood as a recommendation for investment. For more in-depth analysis and interpretation, we recommend consulting suitably qualified persons, for example, patent attorneys or trademark consultants. So we say also that how far can we go? how good we are. We are good at search, but we are not good at giving advices. So if you really need some advices, go to the people who are paid for that. We are just there to show you what documents might be of relevance for you and not how to do. And if you think that, for example, this document is not good and you did some investment, and afterwards it finds out, oh, the document was quite relevant, it is your own fault. We did not give such an advice, and we don't give such an advice. So we try to be, in fact, quite clear on that. Then there are other aspects we actually make clear, as for example about copyright and right of use. Again, you remember we talked about that, about what is the scope of use, how far things can be used. First of all, there is no copyright transfer to the customer. We send them normally actually a report. This report is of course maybe involved with some copyright. We don't give them the copyright on that. There is no transfer of copyright. Then all services are intended for the customer's own use only. So that is a way to make sure that your know-how will not be transferred to anybody else, to one of your, let's say, competitors, or in the case of information brokering, for the own use of the customer's customer. So if, for example, we are dealing with a patent attorney, and the patent attorney is working for some other, let's say, customer, and he asks it in order of that customer, he can give it to that customer. But that is all. It is not that they can actually show it, as I told you, to some other competitors. In the case of a transaction on behalf of a third party, the data may be forwarded to the latter once only. Duplication, distribution, and reprinting for the purpose of further commercial use are prohibited. Again, uh, that is the limitation of use, as I emphasized several times, and it's quite important to, let's say, emphasize it also here, what is allowed and what is not allowed. Here's, for example, you cannot use our, let's say, results or patent report or patent search report in order to make some publicity for yourself or for anybody else. Then about confidentiality, that is what it is about. We actually say everything will remain confidential concerning all type of search. So everything you wrote to us, or the customer wrote to us and we write to them, remains. In fact, all these, let's say, transactions remain under confidentiality. What happens for the payment? They have normally actually to pay in, let's say, in delay of 30 days from the date of invoice. Then fees and interest will be calculated from the second payment reminder. So the first reminder is just, we say, ah, you maybe forgot that. But for the second one, there will be some fines which will add. Interest will be calculated at the rate of 5%. So we actually even say at which rate we are doing that. Everything is transparent. For payment delays for more than 60 days, the customer shall pay a 100 franc processing fee. That is our administration fee. People actually have to write that reminders and so on, so that these are the administration fee. And again, transparently, we say it from the beginning, so that at the end, if there is a problem, we can say they knew it. The guy actually signed that contract. He knows what it is. This fee is also payable even if no payment reminders are sent. The principal amount owed is not affected and continues to be due and payable. So then, uh, uh, again, a very, very, very important part of any contract, I would say, is the question of applicable law and forum. So what is the applicable law? So all matters arising out of the relating to this agreement and to the services by the IPI shall be governed by and construed in accordance with the internal laws of Switzerland. So we decide that is in fact uh, uh, the law which governs this agreement is the Swiss law. And we also stipulate actually where is the forum. That is actually in that case the city of Bern. So uh, also we try to make clear what effect would it have the in the case of conflict with the actually international or private law rules. Then the forum in that case is said in the second part, any claim or dispute arising over relating to this agreement and the services by the IPI, regardless of the cause of action, shall be adjudicated exclusively by the court of the city of Bern, canton of Bern, Switzerland, and each party irrevocably submits to the exclusive jurisdiction of such court. So um, of course, that is actually because we know the law. We can handle it quite easily, and most of our customers are coming from, let's say, a jurisdiction that they are familiar with that, so there might not be a problem. Again, I'm coming back to that questions when I'm talking about licenses, and you see actually for the case of licenses, it is maybe not that easy because we are maybe dealing with some international let's say, partners. And of course, the international partner, they know their own law quite good. You know your own law quite good. So, yes, it's now the question, what is the forum and which law? So, again, um, we will talk about it a bit later, so I don't give any answer to that now, but think about it a little bit because that is a very important question. What shall be the applicable law? Who, which forum is actually responsible for that? That has also, of course, a fair and to deal with the question of enforceability. Think about the fact that you might have right, you might actually use this forum, for example, the Bern forum, and will be given right. So actually, um, yeah, you won on the whole aspects. Of course, the judge says, yeah, you're quite right. You win that, let's say, in front of the judge. However, can you enforce it is something else because the enforceability, it is also a question of a place. Let's say, for example, you win against somebody in China but in a Swiss, let's say, court. So the other actor is situated in China, but in fact, the court is in Switzerland, the court of the city of Bern. You win it all. Okay. Is the judgment of, let's say, a judge in Switzerland, in the city of Bern, also applicable and enforceable in China? That is the question you have to ask yourself when you are thinking about applicable law and, of course, the forum. So now let's talk about licenses. In fact, licenses are the contracts that you might be most involved in. So I told you before, it is not the only contract. All the other contracts which might lead to that shall be also seen as quite important. But the one which is mostly actually important for you in your daily work is maybe license. So I would somehow concentrate on licenses, knowing that the terms which from which I am actually talking are also valid for other types of contracts in the whole technology transfer environment. So one thing is quite important about licenses. So the fundamental problem of license agreements is that there are quite interdisciplinary approaches. So on the one side, you have, of course, the law part. It is a contract, so it has to do with law, and it is it is a law tool. It is a law object that can be then also validated by a judge. On the other side, of course, it is about technology. It is about a technology, and the law object is about this technology. So you might need not only the law, let's say, information. You shall not only be a lawyer if you want. On the other side, you have to understand somehow about the technology because that is also at least as important as it is. And all these together is because of economic questions. You are doing these contract, these, let's say, combination of law and technology for economic questions. So you have, in fact, all three aspects in it. So it is inherent that there are some difficulties upcoming because of the interplay between, let's say, jurisdiction, technology, and economic questions. And that is also very, very important because licenses are quite important agreements, let's say, especially for the case of technology transfer, or even actually for other questions, as like, for example, license agreements in due diligence for merger and acquisitions or for financing, etc. So all that are also quite important. And then, of course, we don't forget that the real reasons of for some these licensing can be quite different. So it can be actually some licensing in order for the sake of production. There might be licensing necessary for the sake of distribution. That is mostly the case for the softwares. Then, of course, I told you, you do some licensing in order to earn money, so to generate income. Or people actually also use licensing. We talked about it when we talked about the IP strategy, that one of the matters that are quite important nowadays are setting standards, and by licensing, you get that standard actually possibilities. So there are different license forms possible. You might have the so-called pure licenses. So pure patent licenses, or a pure know-how license, a pure trademark license, a pure design license, where you actually, the subject matter is actually purely just patent or just the know-how or just the trademark or just the design, nothing else actually involved. Then I have to say that it is normally not, especially for the case of patents, not enough. It is not just the patent. You let somebody use your patent, and it is. Normally, you need some know-how how to do it. So these combinations you will find in the so-called hybrid agreements. These are mixed agreements when actually you have several parts, one, at least two of what aforementioned was. For example, a hybrid agreement between patent know-how can be also actually a hybrid agreement between actually patent know-how and trademark. So these are the hybrid agreements. Then you can think of vertical agreements, and also about, for example, horizontal agreements. So when we are talking about horizontal agreements, then these are um, uh, among parties that, in fact, are somehow in on the same level, so they are competitors. When we are talking about actually horizontal agreements, there is a license agreement between two competitor firms. In the case of actually vertical agreements, It is mostly in the same company, but there are maybe different, let's say, unity of the same country, so of the same company. So in case of vertical agreements, you are inside a whole corporation, for example. Then you might have the cross licensing form. So that is actually two companies are licensing to each other in a cross manner. So I license to you to use that, and in return, you license me to do that. I use actually your other know-how or your other actually patent. Then uh, it might be actually also some sort of uh, intra-group license agreements, which is quite important for antitrust law, depending on the country. So uh, it is for the intra-group license agreements. Then the good thing is that actually you can avoid some antitrust law application then into your company. So that is actually some really actually also political reason why doing sometimes such sort of agreements. Then there are actually we are talking also about hidden licenses or hidden actually R&D agreements. So uh, these are licenses which are not expressis verbis, but the content of the contract still counts. So these are agreements which are not maybe existing even in written form, but it is still accepted from both sides, and both sides are using their rights and their duties due to that arrangement. So first, we have to talk about what is a license. It was somehow discussed before. License are the contracts sui generis. That means actually these are contracts of their own type and art. So, and as long as the principle of freedom of contract is applied, as in many countries, it has no special limitations, except, of course, for the national antitrust law, or if you are an international, let's say, contract, that is the antitrust law of the licensee part. So the limitation is somehow given by antitrust law, so you cannot actually go beyond that. Then there might be different types of license contracts. As for example, the normal one is actually the one we all know about, is the so-called single license. That is just a license to use or whatsoever to let's say single entity, and that does not exclude any other person to have another license and so on. So it is just a one license. Then you can have also the exclusive license. That is actually, in that case, the licensee is the only licensee. That is has no other, in fact, competitors can have a license on that, and that is the only one who is allowed to use it, to sell it, to let's say produce it and so on. So exclusive license is a very special sort of or these license types. So there are a lot of duties and maybe obligations which are somehow related to that type of licensing. So once you have an exclusive licensee, for example, you are not allowed to sue the licensor. So that is one part of it. Then you might have, for example, the sole license. The sole license is actually not an exclusive license, but you are the only one. So that is actually a sole license. That is actually non-exclusive, but only one license. That is the sole license. That is, for example, also the owner can use it without any problem. Then you have, when you have exclusive license, you have also the non-exclusive license. A single license is, for example, a non-exclusive license. Then you might have license type sales license, manufacturing license. So you can have mix of them. You you can give a license to a distributor just to sell it. It might be only just to manufacturing it. It depends on actually also the subject matter of license, because as for example, if it is some trademark license, you don't maybe want to accept the manufacturer by anybody else, but there are only licensed people who are allowed to sell that mark or trademark. So then you have also the possibility of license to use. As said, you shall be quite careful what use, and the use shall be clearly defined in order to have the limitation. Or if we can have also a sub-license. And in that case, actually, the licensee can sub-license to another licensee. So you are a sub-licensee of a licensee of a licensor. Even these types of licenses exist. However, of course, the right to have sub-licenses is a right that shall be cleared in the license contract of the first licensee, of the primary licensee. Then you might have also the negative licenses. The negative licenses are, for example, a sort of license. um, it's not very usual, and it is not very liked by judges, because it is going in the direction of a sort of against antitrust law and so on. So a negative license is when the licensee is not allowed to sue, let's say, the licensor. So in fact, there is a negative right. You give actually a license for a negative right. So that is also, which is which can exist, but it is not something that is very welcome. Then there are even actually free licenses. So people might be even in some cases quite nice and give some free licenses. So it means actually is license that is given to a company to use or to sell, to manufacture whatsoever the subject matter is, the license subject matter, without paying any fees. That is actually a free license. Especially for the case of free license, I would say be careful of uh, other terms which you have in that. As for example, let's see, actually, you are a big company, and then you have actually some young people are coming to you and say, oh, we want to actually use these your patent in some other area which is not in conflict with yours, and we would like to have actually a license. And because you think they are quite pleasant persons and quite actually dynamic young students, why not you accept and accord them a free license? So what can happen? That is actually an example I bring because it is a real example. I've seen it myself. That in fact, after some years, this small company, was bought by the biggest competitor of the big company, because they knew that they have this free license. And the point was that in the license contract, it was not written expresses verbis that the license is only valid for this company and not in the case of a transfer to another company. So, in fact, indirectly, by buying this small company, they had a free license for one of the most important, that's products of these a bigger company. So you see, in fact, just by omitting of these type of, let's say, reflections and thinking about what can happen, you might give away a huge part of your competitive advantage. So that is a quote that you shall take into account and also try to be careful about. So you shall also think in different scopes when you're thinking about licenses. For example, think of the personal scope of application. What it means is, in fact, when you are editing that agreement, think about who is the licensee. That is the personal one. Is it the whole company? Is it just an entity? Is just the part of a big corporation in a certain country? So, in fact, the personal scope of application shall be clearly said in the term. So, who is really the licensee? Just writing, for example, the name of a very big company like Nestle, what does it mean? Which part of Nestle? So be careful who is really in your eye, your partner with whom you are talking. Then, of course, you have to think about it in geographical terms. So the geographical scope of application. So that shall be a fit to patent situation, for example. If it is actually just about a pure patent, let's say, license, or is it about a pure trademark license, then it shall be a fit to that situation. You cannot have a license in a country where your patent is not valid, of course. Um, on the other side, if it is about a know-how license, that can be worldwide because know-how is valid everywhere. So, and you gave it under some, let's say, of course, confidentiality aspects. So, and about in that confidentiality, we have also to think about actually that just by telling that something is actually confidential and this secrecy agreement, it might not be enough because you have to define in those secrecy part what should be reasonably defined by secrecy. Okay, so you cannot just say, okay, that the information I will give you is actually secret. No, you have to say what is reasonably defined by secrecy, what you want to keep secret, and then for how long. So that's actually also another thing. You have to show them and actually write it down what happens when it comes to a publication. So if it is publication by third parties, if it is your publication, and if it is actually the publication by the licensee part. So that all those cases shall be also treated and be clear. Then also if it is during the negotiation, when you need actually that secrecy, then try to split the time to negotiation in secrecy and then the part which is a non-secret. So also that shall be quite clear in the terms of secrecy. Then back to the scopes, you might also think about the temporal scope application. As I told you again and again, in fact, you have to be fit in, let's say, in time or temporal actually view. So normally so that the paid royalties are not paid back. So you have maybe also to mention that what is paid cannot be given back. And there are difficulties if, for example, patent expires after the license. So mm, there is a difficult problem. So can you actually these time discrepancies might really actually cause some problem. Um, there is a general rule uh, that is, for example, yeah, it is, but it is not, let's say, accepted overall. Is that actually what is produced but not delivered can be in fact can be delivered. So you are in the case you produce something and the license time goes out. It was produced during that license time, but yeah, if actually the license time expires before the patent time, what happens is in fact, okay, I can actually keep everything and I don't sell up until the day when the license expires, and you can actually you can sell everything afterwards or give out everything afterwards. So the point is that is a real problem for the licensor who will not have the money. So you have to find actually a way to avoid that type of problems also. Then another very important point is actually the scope of application as to the content of the license. So, for example, is it a manufacturing license? Is it a sales license? uh, or is it an in-out license? Is it a license to use? So what is actually the content of that, let's say, a license? So just to give you an example, um, let's say exhaustion by a sale license, if the right is not exhausted, and if the exhausted distribution agreement, what happens in that case? So there are uh, really also in that cases very important to clear up all possible outcomes, and then to think about them and to mention them in the contract itself. So we are also having some obligations and some rights. So typical rights and obligations, which can be defined by a licensor or by a licensee. From the side of actually licensor, it is the obligation to give info and warn if something goes wrong. Is, for example, if there is something happening with the, let's say, with the patent is actually sued for invalidity and so on. You have to warn people, in fact, and your licensee, so that they are aware of what can come. Then it is actually the right to tolerate the use, and there is obligation even actually the use of the subject of license by the licensee. So you cannot actually afterwards, after actually all agreements, say no, I'm not agreeing that you can use it, when you have this agreement that he can use it. So that is again another point which is quite clear and does not need any further explanation. Then uh, it is the obligation to provide the usage on the subject of the license. So it is actually quite clear what is it said here. It is you have to you are interested as a licensor that the licensee can use that because he pays you back by using your contractual good. Then another thing is about actually its maintenance and defense of the IPR. Though quite clear is actually it's, for example, an application, then it is again in the interest of licensor to keep it alive. So the payment for royalties, request for examination according to let's say, patent law in that country and so on. So, or whatever it is needed to maintain that IP right. However, if it is not written, there is normally is no obligation of enforcing the right for the licenser. So as a licensee, I would be very happy if that happens, and then the licensor is in charge of, let's say, enforcing the right. In some cases, it is more or less clear that it is actually the obligation of the licensees. For example, if it is about an exclusive, if it is about an exclusive license. In that case, of course, the exclusive licensee is the one who is also in charge of enforcement. For all other cases, it is an obligation for both parties to write it down somehow. So, who is in charge of the enforcement? And then the other way around, what happens when actually third parties make some claim, say that the patent is not no more valid, or somehow actually you are infringing a third party's patent by using that patent and so on. These liability regarding third party claims, is it who is liability, whose liability is that? And of course, in the first part, it shall be the liability of the licensor. Again, it would be quite interesting to write down that somewhere. Then coming to, in fact, the transfer of know-how, you have to make it clear in the contract what is the secret character, then how these transfer of know-how done, and you can and you shall in fact also identify the know-how. So all that parts, how it is done, what is it, what is the subject of that, in which let's say under which circumstances the transfer is realized, all that shall be stipulated also in that contract. Another let's say more or less obligation of the licensor about the adjustment in case of disclosure of the contractual know-how. So what happens if that secret contractual know-how now is published somewhere, somebody else did it, and now everybody else knows it. So in fact, that is a huge problem for the let's say competitive advantage of the licensee. So in that case, there shall be an adjustment. Then adjustment shall come from the licensor because you lost part of it. Again, an adjustment is needed in case of invalidation of the contractual IP right. What if the patent, especially in the case of the pure patent, if the patent, which is the subject matter of that pure patent license, dies because or invalidated. So it seems to me clear that in that case the license will die as well. It is not the same case if it is, for example, for a hybrid agreement where you have on the one side the let's say patent, and on the other side, of course, also the know-how in it. So in that case, invalidating patent does not mean that the whole license will die. So, but you need to have some adjustment in that case. Then when we talk about warranties of the licensor, for example, the duty to procure, warranty for lack of legal deficiencies of the patent, all these warranties and so on, about actually usufruct, or about granted to the licenses which are granted to third parties and so on. Uh, there, as a licensor, you shall be very careful, because sometimes you are giving some guarantees for future existence, and you are not sure that you can give that guarantees for the future existence in the case of, for example, a patent application which is still not valid, or it is enforced but it is not examined. So these guarantees, also in these warranties, what you put there, you shall be sure that you can really afford them even in case in future things will uh, go the other way around. Then also the warranty of the licensor against defects. He has a liability for technical operability and utility. When if the patent does not function, if the idea does not function, and so on, and it's technically not possible to do that, sorry, but there is more or less it comes as if it was a fraud. So you have, as a licensor, of course, also the liability that it works technically, and the liability about the precise specification as to the contractual goods. These things are contractually written, so you are in fact in charge of them. Then uh, you can provide the right to grant sub-licenses. This is again something you have to think about it if it is really needed or not, because that can it's not a natural right. You can actually accept or not. Uh, in the case of actually an exclusive license, again, it's more or less comprehensible. In other cases, be careful about that. So under which circumstances you can actually sub-license things. If it is actually a non exclusive licenses, single license, and people have the right on sub licensing that, it might mean that actually you don't earn money yourself. So sub license, or what are the terms for sub license? So also that case, even if it is possible, it shall be thought of thoroughly. Then on the licensee side, there are also rights and obligations. For example, it is very, very understandable that the, let's say, licensee has to pay the royalties, so the payment of license fees. So, but it is not that, let's say, trivial. What is and on which base do you use that? For example, is it a royalty based on turnover? Uh, and turnover is not a trivial sum. Uh, shall we actually uh, take into consideration everything, or only the considered part which has something to do with the subject of license? Cannot, it's maybe actually the whole product is just part of it is actually protected by the patent and the know-how. Shall we take a whole turnover and actually take that one, which is not really actually accepted by most of the licenses? So then you can maybe think of a per unit royalty. Again, the per unit royalty is actually which unit. So what is actually what shall be taken as a unit? So, for example, are there units without being sold? Because if you actually, for every unit which is produced, you have to pay some royalty. It's not very attractive for the licensee. But if you do it for the sold one, again, which part of the sold unity? Then most of the cases you start with a lump sum, which is actually you have, let's say, it's sum of money which you pay at the beginning in order to start with that, and that is actually which is quite well functioning in the case of let's say know-how. Let's say patents that you may sum to access that know-how at the beginning. Then people actually are asking for a minimum royalty, so that at least there is let's say you earn some money if the other one does not produce everything. And these actually minimum royalty shall always be combined with an obligation to use, especially if it is a big competitor. Um, because big competitors have maybe their own solutions, and they want just a license they pay for that in order not to use it so that their solution becomes the standard. So if you have that case, make sure that actually it is not just actually a minimum of let's say royalty, but also at least some minimum use. And then another right might be actually the accounting obligation. So uh, again, in that case, you have to have at least a minimum royalty clause. Otherwise, if the guy is not really do the best effort to do that, maybe he does not. You have a license contract and you earn nothing. So that is the thing which is very important. Then entrance fee, that is actually a fee to be paid at the very beginning, especially for the know-how and so on. And so that is in fact at least the value of your know-how, which is somehow validated by that entrance fee. You might have the no challenge clause in that. If you have that no challenge clause, means in fact you cannot sue the as a licensee, you cannot sue the licensor to challenge the validity of that. Let's say the IP rights, and that is uh, it is a clause that can be included. However, for certain cases, depending on how it is actually, how the license is, it might be thought of being too severe, especially if you are in a forced position as licensor and the other one has no other choice. So that is again something which is acceptable, but under circumstances. Then uh, the obligation of use, and that is the best effort clause, which is very important. Make sure you have that in the contract, especially as the licensor, in order to be sure that you can earn money, and he does his best that the let's say that the at least the subject matter of agreement is also really used. Then the examination of account books is also the licensee cannot somehow not provide the accounting books to the licensor, so he has to give the right of the examination of his account books to the licensor, so the licensor knows, okay, if it is correct, the amount of money he receives, yes or not. So that is again something which is quite important for the licensor, and the licensor cannot keep it for himself. Then the licensor can ask for a minimum quality standards and the right of control, because he was not want that his trademark afterwards is actually somehow destroyed by the let's say not sufficient quality of the product of the licensee. So this is also actually an obligation of licensee to the licensor to give him the possibility of the quality check, and also control of the let's say licensed good. Then uh, there is an obligation to inform about improvements. So that is another point which is quite, that shall not go so far that the licensor asks if you have some IP rights to improve that, then it shall be to my name and so on and so forth. Of course, there are, but he has the right to ask. The licensor has the right to ask the licensee to be informed if they are working on some improvement of that, let's say, technology. So, and he has the obligation to inform him if there are some points that could be interesting for him. So another important point is also maybe about the tying obligation or compete obligation. That tying clause is actually a clause that is accepted under circumstances also. Um, Again, the limitation to that would be antitrust law in different national provisions. The tying obligation is when the licensor obliges somehow the licensee to buy parts only from him. So he ties the license to also to some goods which is also provided by him. It is quite reasonable in the case of, for example, a trademark. Let's say a trademark license. So, in fact, because of the quality problems and so on, it is necessary that also the good somehow has the quality which is in accordance with the trademark, so that actually the good is also delivered somehow, or part of the goods is delivered by the licensor. The case of actually the patents, this tying obligation shall not go over, let's say, a certain limit. So, especially if it is an abuse of the position of the licensor. So, licensor is actually in a such a predominant position that the licensee has to accept everything in order to have the license. In that case, he might actually make some tying obligations which are not accepted, at least quite accepted by the judges afterwards. So another thing is about non-compete obligation. So again, if it is not limited by antitrust law, these obligation can be accepted, can be part of actually the license. So you are doing in these marked, and I will do in another marked, things like that are accepted. However, again, in that cases, you might come very rapidly to the antitrust law provisions in different countries. So shall be very careful about that. Then there might be also some restriction on use, depending on which type of restriction and which type of use, and they shall be also part of the agreement. So the licensee, as soon as he accepted the terms of that, he has to keep it like he was told so. Then, of course, not to forget is about the secrecy agreement, and also the secrecy agreement, what shall be kept secret and so on and so forth, as long as it is written clearly in the terms of the contract, how to treat that, how to treat with the secret materials, how to give it back, everything is also the obligation of licensee, as long as it is written in the contract, and you have to make sure that that is the case from which side ever you are. Then uh, quite last part is again about sub licenses. Do you need, for example, a sub license clause, which yes or not? In that case, you have to agree that. So, or shall, for example, the licensor be able to give licenses to other people or not? In that case, you have to make sure that that is always also question. So this question of sub licenses from the one part and from the other part shall be clear, so that nobody can actually afterwards come to a situation where there is no answer to that. So all that has been said is in order to aware to make you aware of, let's say, all types of problems that can pump up. It is not everything which I said here. It is just part of it, in fact. But What I wanted to do in that is not to give you actually let's say in one hour, 1.5 hour, a thorough, let's say, teaching course of the law of contract. It is not possible to do that, of course. But what I wanted to say is that, in fact, think about different possibilities, uh, from which side ever you come. If you are from the side of actually license, or if you are from the side of a licensee, you have to think of all the possibilities. Try to cover as much possibilities as you can. Everything which is not covered would be a problem as well. Then think, last but not least, about actually about infringement cases, or for example, about a challenge of the validity of IP right through opposition, revocation proceedings, and so on. So these things can happen from both sides. Try to clear it up of that thing. Then once you are using that, once we are at actually drafting that contract, that license contract, don't forget to mention the termination of the license contract. What is the expiry time? What are the costs for a termination? Can, for example, the change of control, as I told you in the example before, change of control might be a reason of cancellation, termination of the contract. That these costs shall be there. Otherwise, you might have real problems afterward. Then or contractual termination terms, under which circumstances a clause concerning the right of use after the termination of the contract, selling of or already produced goods after the expiration of the contract. Because what happens if the contract is actually, let's say, is finished before the expiration time of the patent, and then the other one still actually sells some or delivers things which should have been delivered before, but because of lack of some let's say goods, they could not do it. So now they can deliver it, and that is a question which might cause a lot of problems to both sides. So I'm going just rapidly about actually the material transfer agreements. That is also, um, let's say, a sort of agreement that you might find very often in a certain industry. These are actually contractual documents which are used for acquisition of various biological and research materials. So you find it very often in the case of biotechnology. Occasionally, there are also about data which are developed by non-profit government and private industry. These materials are, in fact, normally necessarily a component of a research project, and they can actually be available only from a sole source, so that you cannot actually access them from somewhere else. So only these companies have those data, have those material, and that is actually a very special case. So you have to have an agreement for the transfer of that material. um, Typical material transfer agreement provisions are that, I wrote it down. It is a very special case, as I told you, very often in biotechnology. So some of you might be very interested in. So I put them there so that you see what is important there. So, for example, you have to specify the purpose of that material transfer. You have to, let's say, make restriction on that transfer. Was the purpose of that, let's say, transfer? Who has the supervision duty? What are the compliances? Then, of course, it's very important that the recipient shall not use the materials in any other manner that confers on any third party any proprietary right. So it has to, in fact, use it just in the limit of the contract you have, then of course it would be quite important for the owner to have this clause of no reverse engineering or modification. He wants to have his material back without that the other one maybe finds out how it works and so on. Then again, maybe actually they make some investigations on that, and there are some intellectual property and other patents which come out of it. Who has the ownership of that intellectual property? So again, contractually, you have to keep it in mind. So do you have at least a co-ownership as the one who has this material, yes or not? Or, of course, from the side of investigator, he wants to have actually the ownership of the whole of it. Then once you might use it, who has the right to use that know-how? And of course, once the question of ownership is cleared, then you can know about actually what type of licenses and who license that invention to other third parties. There are also other, let's say, provisions which are quite important. It might be important or less important, but these are actually at least the basics you have to know before going further. Uh, let's come to the last slide and just mention some tricks and traps that can, let's say, pop up for your contracts. So it is very important, and that is actually the takeaway I give to you. Think of the type of the use or use for certain products. And that might actually be tricky afterward if it is not clearly stipulated in the contract before. Um, think of the geographical scope of also the contract. So make a local restriction and determine actually the territory where actually the contract is valid. Then I gave you an example about forum and I asked you to think about it before. Now I come back to that question again. Uh, First of all, you have to decide which law will govern the contract. So maybe, as I told you, most of the time, the parties or the party who has the right actually to ask that, he tries to have his own law because it is quite he knows the law and actually he knows how actually the law functions. Uh, on the other side, let's say, as I told you, you have, let's say, Swiss side, and you have actually a side from Switzerland, and another side from let's say, China. Then you decide that the law which governs the contract is actually the Swiss law, because you think you know the law and you wrote actually the contract in terms that the law is actually quite conform what you thought to write at that moment. However, now you try to find the jurisdiction actually, or the forum actually, in which forum you want to do that, let's say, jurisdiction. Okay, you keep, because it is Swiss law, I would do it actually also in Switzerland. Okay, you do it in Switzerland and you will win. However, the let's say, the judgment of that judge in Switzerland is of no use for you in China, where the infringement happened, because this company is now in China, and you cannot do anything against him with a judgment in Switzerland from a Swiss judge. So think maybe it is other possibilities which are a bit more tricky but quite good. You can actually, let's say, accept that the law which governs the contract is actually the law of Switzerland. However, the jurisdiction is in fact the judge in China, so that the judge in China has to decide due to Swiss law, but what he decides is then enforceable in China, because that is not a Swiss judge, that is actually a Chinese judge who decided about that. So in that case, you have the enforcement. So the question, which forum, which, let's say, which jurisdiction, let's say, scope, and which law is also a tactical and a technical question, which is quite important. Think of infringement cases, think of what can happen. And then also think of the cases which, especially for the international corporations, as I gave you an example, that might not be acceptable for both sides. So, are there any alternative dispute, let's say, regulation, for example, arbitration or mediation? These are also, let's say, some battle courts which can be taken into consideration, and they would give you a satisfactory result in most of the cases, instead of choosing the forms, the, let's say, the usual forms, the battle in front of a court in a country. So uh, there are several possibilities. There are different possibilities, and not all of them are suitable for every situation. You have to think about the situation in which, let's say, combination you are, and decide about these questions due to the given situation, due to given combination you have.